Hunter Biden had a really bad day in court the other day when he went in to go ahead and settle his case with his tax evasion and gun charge. Well, the gun charge that he's not going to be charged with. And it was going to be an easy day. All he had to do was go in there and plead guilty. And the prosecution already had a deal set up with the defense. And normally it's an easy day, but it wasn't an easy day for Hunter Biden. And he left without a plea deal, and not only that, but he left with some release stipulations that he may or may not have a hard time following, but we'll see. Let me tell you all about it. Go ahead and like and subscribe first. Now, before we talk about what happened to Hunter Biden in court, it's really important to understand what happened with his lawyers the day before when they tried to pull some shenanigans and get something removed from the docket. Let's go ahead and look at the filing that was put forth by the congressional attorney, Mr. Catilla. Letter together that Theodore Catilla from Congress, or the law firm that represents Congress, sent over to the judge about what happened. Dear Judge Norica, our firm represents the Honorable Jason Smith, Member of Congress and Chair of the U.S. House of Representatives Ways and Means Committee. This morning, our firm filed Chairman Smith's motion for leave to file amicus curiae brief and aid of plea hearing together with the proposed amicus curiae brief. We received an email from counsel for defendant Robert Hunter Biden advising us that the materials that we filed, which are publicly available, violated the court's rules because it contained grand jury and confidential taxpayer information. See Exhibit A at 6. Defendant's counsel did not provide any details regarding which materials should have been filed under seal. And just for backstory of what materials they're talking about, these are materials from the whistleblowers that have come forward recently that were working on Hunter Biden's case. This was sent over to the judge as some extra information saying, hey, judge, you might want to know this before you go ahead and just let this plea deal go through. We responded that this filing included only documents which had been made publicly available on the House Ways and Means Committee's website, right there. See Exhibit A at 5. The exhibits that were filed have been public since June 22nd, 2023, following an approved vote of the House Ways and Means Committee. Moreover, the documents that were made public were redacted by both counsel for the minority and majority members of the Ways and Means Committee. Counsel for defendant Christopher Clark, Esquire, advised that we would be moving to seal the record. Or advised that he would be moving to seal the record. See Exhibit A at 4. Following this exchange at approximately 1:30 p.m., we received word that our filing was removed from the docket. We promptly contacted the clerk's office, and we were advised that someone contacted the court representing that they worked for my office and that they were asking the court to remove this from the docket. We immediately advised that this was inaccurate. The clerk's office responded that we would need to refile. We have done so now. I advised opposing counsel that we were deeply concerned by this conduct. Opposing counsel admitted that they had contacted the court, but argued that they had done nothing improper. In further response, Mr. Clark stated, I stand by all my statements, and I hope you have an affidavit from the clerk in support of yours. See Exhibit A at 1. Attached as Exhibit B, please find an email from the clerk's office supporting the statements. If Mr. Clark or other counsel wants to move to seal publicly available documents, he should do so by way of motion, and we will respond accordingly. We remain available at the convenience of the court if there are any questions. So now let's take a look at this email exchange. Here's the email where Christopher Clark, a partner with the law firm that is representing Hunter Biden, he says, Ted, I stand by all of my statements, and I hope you have an affidavit from the clerk in support of yours, Chris. So a nice little snarky email there. And here's what Catilla comes back with. Chris, you should probably take a step back from your statements. The clerk's office advised that it was represented to her that the request was being made by my firm. We will be advising Judge Norica of this improper conduct. Very truly yours, Ted. Ted, your email is inaccurate. As far as I am aware, the managing attorney from Latham called the clerk's office to note that personal tax information of the defendant had been filed in a redacted manner, and to inquire regarding having the information sealed. As we told you we would, and as you said you understood. As far as I am aware, the clerk took the filing down on their own accord. So we can already tell this is a bunch of lies, right? According to what the clerk has already told us. Your attempts to publicly file my client's personal financial information with no protection are improper, illegal, and in violation of applicable rules. Please follow the rules in making your non-party and non-approved filings. We will seek all appropriate sanctions in response to your actions. We will seek all appropriate sanctions in response to your actions. So you can see that Chris Clark of Latham and Watkins is still the arrogant ass. Someone from your side unilaterally contacted the court and had our filing taken down. It was represented to the court that there were social security numbers in the filing. The clerk was also under the impression that this was my firm's paralegal that did this. This is not accurate, and the clerk's office has been made aware of this. We ask that you immediately provide your basis for what you claim should not have been publicly filed, as we believe that this was improper. If you want to move for a protective order, you must move for one. Very truly, Ted. Now this is the email to Theodore Catilla from Samantha Grimes, the clerk, or the representative of the clerk's office. Hi, Ted. Following up on our recent telephone conversation, the woman who called was a Jessica Bingles, and her phone number is that. She said she worked with Theodore Catilla, and it was important the document was removed immediately, or they could file a motion to seal. I do deeply apologize for all the confusion on our part. I have put the rest of the clerk's office on notice that if someone is trying to do anything with the criminal or MJ case, they need to contact me. Again, very sorry for the confusion. Regards, Sam Grimes. Well, needless to say, the judge was not pleased about that, and she ordered the lawyers from Latham and Watkins to show cause and explain themselves why they should not face sanctions for what they did. Very dirty. So, when Hunter Biden showed up to court the next day, things didn't go as they planned, and what they were expecting was to walk in there and get this deal rubber stamped. The judge was not having any of that. And I would imagine the actions of his lawyers the day before probably had a lot of influence on that. But long story short, Hunter Biden walked out of the court without a plea deal. And he also walked out with new terms of release. And here they are, actively seek employment. Probably not with Burisma. Not use alcohol, not use illicit drugs, submit to drug testing, and not possess a firearm. So how long do you think Hunter Biden's going to be able to abide by those stipulations? And I wonder when his first drug test will be. He told the judge that he hadn't done any drugs in over a year or 2 years since June of 2021. So he should be clean, right? We'll see. Well, I hope you got something out of this, and I hope you understand what's going on with the Hunter Biden DOJ thing a little more clearly now. Leave me a message down below, leave me a comment, let me know what you think, and hit the like button on this video, and please go ahead and subscribe to this channel if you haven't already, and join this big old family. So, until next time, peace be with you.